I know many of you are listening about these Supreme Court decisions. People have been doing their best to explain them, I understand, but this is what I'm born to do. First of all, let's set the stage here. The Supreme Court is only deciding these cases because of an imperial president, because of Obamacare, the Obamacare law that the Supreme Court upheld. So before we have a parade for the 5 justices on the court, before we cut up our confetti and get it ready, just keep in mind that the Hobby Lobby case wouldn't even be necessary, but for Obamacare. There are 4 justices on the court that deserve our support and our thanks with respect to Obamacare. So that's number 1. Number 2, I don't know about you, but a great republic like this, where we're all sitting on the edges of our chairs every June, hoping a decision goes our way and so forth and so on, 5-4, that's not how a republic is supposed to function. Even these decisions, by the thinnest of majorities, could have easily swung the other way. That's number 2. Number 3, and this is where some people have difficulty comprehending what the court did. These 5-4 decisions today, which I'll discuss in plain English momentarily, demonstrate to me that the majority, Sam Alito, who is definitely going to be one of the great associate justices ever on the Supreme Court, they demonstrate to me that John Roberts and or Anthony Kennedy required Alito and Scalia, and Thomas, of course, to have to go along with a majority opinion that wasn't as strong as it should have been and could have been. And then number 4, in the case of the Hobby Lobby case, it's actually 2 cases, as I'll explain in a moment. Obama lost, and yet the Constitution was damaged. The Religious Liberty Clause in the First Amendment was damaged, just as Obama lost last week 9-0. But the Recess Appointment Clause in the Constitution was damaged. The reason is none of our presidents have so completely and radically rejected tradition and practice when it comes to the Constitution that Obama just keeps throwing political hand grenades at it, and so it goes up to the Supreme Court, and the Supreme Court's deciding cases it wouldn't normally decide. It's deciding issues it wouldn't normally decide. And when it decides them, you have to keep in mind there are really only 3 reliable originalists on that court. Every now and then Kennedy joins in and Roberts joins in, but there's 3 of them who show fidelity to the process. And you've got the Radical 4, and they are Radical 4 justices. Ginsburg was out of her mind today in her dissent. It was so disingenuous and dishonest in the Hobby Lobby case. More on that in a moment. So this is what's going on the court. This is why it's really ridiculous in a republic of over 300 million people that we all have to sit here, eyes bulging, jaw on table. What are they going to do? What are they going to do? It's the Hobby Lobby case today, the Hobby Lobby case. And the whole society lurches in one direction or the other. That's not a constitutional republic. And the same thing will happen one day when same-sex marriage is being decided by the court, a 5-4 likely decision. Swings one way, swings the... Whoa, oh, now we're over here. Whoa, we're over here. And, of course, that's what the Constitution says. No, that's not what the Constitution says. That's what the justices say. A majority of them. So I just want us to keep this in mind, at least for now. Now, the issue in the Hobby Lobby case, first of all, the way I see it is it's the First Amendment and religious liberty versus Obamacare. And you need to keep something in mind. As Katie Pavlich pointed out at townhall.com early today, the family that owns Hobby Lobby had no moral objections to the use of 16 out of 20 preventive contraceptives required in the mandate under Obamacare. And Hobby Lobby will continue its long-standing practice of covering these preventive contraceptives for its employees. But the family could not provide or pay for 4 potentially life-threatening drugs and devices because it violated their religious beliefs. And these drugs include Plan B and Ella. I don't even know what this is. The so-called morning after pill and the week after pill. And covering these drugs and devices would violate their deeply held religious beliefs that life begins at the moment of conception when an egg is fertilized. The issue here was individual liberty. Now, keep this in mind. People are not stopped from purchasing these drugs. People are not obstructed from purchasing these drugs. It's just that the person paying for the health care in this narrow case, as I'll explain in a moment, said they couldn't do it for religious purposes. And I would say this, why the hell are we paying for any of it? Notice the debate isn't over cancer drugs, or heart drugs, or drugs to deal with diabetes, or anything of that sort. No, what are we debating? What the left always debates. Sex. Genitalia. We've come a long way in the last few years under our imperial president. The understanding used to be that even the federal government wouldn't spend 1 penny on abortion or abortion-related drugs or surgeries. It's called the Hyde Amendment, and it stood for 15 years, was agreed to as a bipartisan approach, and then comes along Obamacare and obliterates everything. Now, the question in this case was whether the Religious Freedom Restoration Act of 1993, passed under Bill Clinton, signed by Bill Clinton, and the First Amendment's Free Exercise Clause prohibit the federal government from requiring certain employers' group health plans to furnish access to these 4 drugs that I was just talking about. 4 out of 20. Not whether people couldn't have access to them, but whether this employer had to pay for it. So here's some background. Companies employing 50 or more full-time employees are required by the Obama law to provide in their insurance plans access to 20 specific contraception methods or devices, which to me is just outrageous. But still, these include these 4 methods or devices with the capability of destroying an already fertilized egg. They're called abortifacients. The contraception mandate exempts churches, but not church-related entities such as a Catholic parish's school or even a Jewish hospital staff. And after a great deal of resistance by the Obama administration, HHS finally provided an accommodation, so-called, to these kinds of religious employers, exempting them from regulations implementing the mandate. Now, today's decision involved 3 separate lawsuits brought by the owners of 3 closely held for-profit companies who have sincere religious beliefs that life begins at conception, that is fertilization, and that it would violate their religion to facilitate access to contraception drugs or devices that operate after that point. So the quintessential pill is still paid for. Other birth control devices still paid for, still subsidized. It's what happens after fertilization. They said, no, we can't do that. That's abortion. So the suits were brought under the Religious Freedom Restoration Act of 1993 and the free exercise laws in the Constitution, clause that is. And under RFRA, the government shall not substantially burden a person's exercise of religion without a compelling government interest, even if the burden results from a rule that applies to everyone in a particular case, here employers with 50 or more full-time employees. Now, in one of these cases, the Third Circuit held that this RFRA statute didn't apply to corporations and ruled in the government's favor. In the other case, the one brought by Hobby Lobby, the Tenth Circuit in Denver held that closely held corporations were persons under RFRA, and that Hobby Lobby had demonstrated that the contraception mandate substantially burdened its exercise of religion. So the Tenth Circuit also concluded that HHS had not demonstrated a compelling governmental interest in enforcing the mandate, or that the contraception mandate was the least restrictive means available to further the government's interest. So the court ruled 5-4 that the mandate violated the 1993 Religious Freedom Restoration Act statute, and since the ruling was made on RFRA, the court didn't even reach the First Amendment claim. Alito wrote the decision. He was joined by Roberts and Scalia and Kennedy and Thomas. Alito concluded the contraception mandate violates the RFRA statute. And he said RFRA does not allow Congress to discriminate against men and women who choose to organize businesses as for-profit companies. And he noted that law applies to a person's exercise of religion. And under the Dictionary Act, 1 U.S.C. Section 1, doesn't get any more basic than that, 1 United States Code Section 1, states that the dictionary is authoritative in determining what words mean in statutes, and the word person includes corporations, companies, associations, and firms in addition to individuals. So entities like Hobby Lobby and the people who own them are protected by the law. Alito also found the mandate substantially burdens the exercise of religion because it operates so as to make the practice of religious beliefs more expensive. in the context of business activities. Here, Hobby Lobby's exercise of religion would cost it $1.3 million per day, or almost $500 million in fines. Alito also said the court did not need to determine whether the mandate serves a compelling governmental interest because the mandate does not pass the least restrictive means available test. In other words, there are other ways the government can ensure free access to all FDA-approved contraceptives. Here's the quote. We do not decide today whether the accommodation complies with RFRA for purposes of all religious claims. At a minimum, however, it does not impinge on the plaintiff's religious belief that providing insurance coverage for the contraceptives at issue here violates their religion, and it serves HHS's stated interests equally well. So the holding is limited, and Alito even addresses Ginsburg's hysterical, outrageous dissent, point by point by point. So it's a very limited decision to certain types of enterprises involving certain types of contraceptives, people who still want to use those contraceptives, still have access to those contraceptives. I'm sure Planned Parenthood will help them if they don't have the $10 to buy them. But the First Amendment was damaged because the First Amendment should never have been dragged into this fight by the Obama administration passing Obamacare in the first place. I should not have to pay for somebody else's contraceptives. This isn't a debate over cancer or heart disease, or diabetes, or anything of the sort. It's a debate over condoms and contraceptives and after-morning pills. We are constantly battling over the left's agenda. To you, did I explain anything to you that said a corporation can impose religious beliefs on employees? The left is so nuts. They so hate unborn babies. It's unbelievable. So now corporations can impose their religious beliefs on employees. If you have a corporation and you work for a company that seeks to impose religious beliefs on you, you have a federal lawsuit, and they will lose. This case had nothing to do of any kind with that. But the radical left can't control itself. And she wants to be president? President of what? And same with Ruth Ginsburg, the former ACLU general counsel. This is some kind of an assault on women. It's nothing to do with an assault on women. Go ahead, knock yourself out. Buy all the abortion pills you want. Why don't you just have that guy who you went to bed with help you pay for it? Why is that my responsibility? I oppose abortion. Millions of us do. And why is this an issue today? But for Obamacare, but for the radical left agenda, but for the supermajority of Democrats that control Congress in its first 2 years that don't even exist anymore, but for these fools on the Supreme Court that upheld an unconstitutional law, Obamacare, and you and I were supposed to throw our faith beliefs, our religious beliefs out the window. Oh, I'm sorry. I guess I'll pay for anything anybody wants. Just disgusting. This Hillary Clinton and Ruth and they're not alone. All the other liars out there pushing their radical left agenda.